evidence threshold will you need? Because there can only be two outcomes, either nullify or uphold.
Now, I'll come to your question in just a bit, but I have to speak as the lawyer on this table, a practitioner of 22 years standing, so I know what I'm talking about. Read the Elections Act, Section 39. It says the chairperson shall declare the result. It is not a may, it's not a maybe, it's not a consultative position. The commission does the election. The commission verifies the results. The chairman makes the declaration. It is unequivocal, it is clear, it's in black and white. That is the law. The Constitution, Article 138, again, in the duties of the chairperson, it says the chairman shall make the declaration that communicates to Kenyans what their decision is regarding the election. Once an election declaration has been made by returning officer, whether it's an MCA decision, whether it's a decision for a president, once the returning officer has pronounced himself on what the decision is, there's no degazettement. The only recourse, now to your question, is a petition. It becomes an election petition from that moment on. But the law did not envision a situation where the commissioners are dissenting. The thing is this, there's nowhere for the commissioners to agree because the Kenyans are the ones who make the decision on what shall be announced. It's not a consensus decision. It's not that they can sit and say, so which number do you like? Do you like this number? Do you like that number? No. All they can do is say, okay, once we have done the tally, we have done the verification, what is it at the bottom? This is the number. Okay, go ahead and announce. And that's why I was saying earlier, if the commissioners had come out and said, when we tallied, we came up with 13, and now a chairman has announced 17, we don't know where he got that from, as it was in the time of Kivuitu. He said, look, I don't even know who won this election, because people were running parallel tallies to his, and he got to a place where he honestly had no idea what he was supposed to declare. Now, Chebukati in this instance, from the very time the commission made the decision to put up the Form 34As up on the website or up on the portal, those numbers were there for any Kenyan with the patience and the temerity to sit down and work out the tally to be able to deliver the result, to be able to arrive at the result even before he made the decision or he made the declaration. So for him to behave as if Chebukati was communicating his personal decision is misleading Kenyans. Chebukati was telling us what we had told him to tell us. It is we who communicated those results. It is not Chebukati who came up with them. And it is his sworn duty to uphold the Constitution and the law. And he did what was right. Now, if there was a discrepancy, like I said, the correct recourse is to take it to the Supreme Court. Once it goes to the Supreme Court, the veracity of what he has done will be tested, as against the veracity of what the entire commission did up to the point where he made the declaration. Because, as correctly pointed out, it is a process, it's not an event. His declaration came at the tail end of the entire process. So when the Supreme Court looks at this, they won't just look at the result. They look at how was the result arrived at. So, for example, the process of verification. How was it verified? How did he arrive at the decision that this has been looked at? Now, this took 6 days because what happened was this. The law saying that the results must be verified, how the IBC interpreted it is that every single Form 34A must undergo scrutiny. And so they set up these little committees. I think the Kenyans saw it on Bomas. Yeah, the Bomas of Kenya. Where 2 IBC officials would sit with 2 agents from each of the 4 political parties that had a presidential candidate, and observers would be milling around. And what they would do is they would scrutinize each and every Form 34A that was presented. These Form 34As did not come by courier like they went to the counties. They were personally brought by the returning officer who sat there in case there were any questions regarding any of the forms that he had presented to them. It was only after each and every one of them had been looked at by everybody around that table, and the agent signing that, yes, what we have seen for this particular Form 34 is correct, that is when they were counted as verified, and that's when they made it the Form 34B. Part of Chebukati's responsibility as chair is to generate the Form 34C. And I've seen in today's newspapers, the findings in this Form 34C have been gotten down from the portal and put in the newspaper. So this information all along was available for all Kenyans, which means the transparency issue was being dealt with, that all along you could see what was the commission working with. And so in this particular situation, my interpretation can only be somebody is trying to precipitate a crisis. The only way for this crisis to be averted, Kenyans have said, is we want to go back to work, take it to court. And so once it goes to court, the process will be looked at, from the procurements to everything to the time when the announcement was made. But where we stand right now, as far as I'm concerned, unless the court says otherwise, we had an election, we have an outcome.
Okay.
And as Kenyans, that's what you asked us a question, we gave you an answer. Now politicians deal with the rest. Not our monkey, not our circus. We have children to feed, we have candidates to prepare. We have a school term that has been shortened by two weeks. We need to get back to normal.